Thank you, Madam Chair. As we've said, my name is Mike McElroy. I'm special counsel to the town of Burrillville. First, I'd like to testify about 714, and then I would like to testify about 769. Regarding 714, obviously the town supports it. The town passed a resolution asking for it. The bill is needed in order to ensure the continued taxability by the town of the Ocean State Power Plant in Barville and the proposed Invenergy facility in Barville. Last year, the Supreme Court decided the case entitled DePasquale, 129 Atlantic 3rd 72. The Supreme Court ruled in that case that a wind turbine that produced electricity that is sold directly to National Grid is exempt from property taxation by the town of North Kingstown. The court's reasoning was that the exemptions from taxation that apply to manufacturing exempted the wind turbine because the wind turbine was manufacturing electricity from a raw material, wind. The DePasquale decision raises significant issues with regard to the continued taxability by Barville of both the Ocean State Power Plant and Invenergy. An argument could be made under DePasquale that the proposed Invenergy plant and the existing Ocean State plant might not be subject to property taxation when their existing tax agreements expire. There are less than 4 years remaining on the Ocean State agreement. The Ocean State plant would have a much stronger argument than the proposed Invenergy plant that it might not be subject to taxation when their agreement expires. The reason for this is because the manufacturing exemption statutes referred to by the Supreme Court have a cutoff date of taking title to generating facilities on or after July 1, 1997. The Ocean State facility was, in fact, built prior to July 1, 1997, so it appears that the manufacturer exemption could become available to Ocean State Power when the tax agreement expires. On the other hand, the Invenergy plant, of course, will be built after July 1, 1997, and so the town would have an argument that the exemption would not apply. However, I'm sorry to say that this analysis is terribly complicated by the fact that the wind turbine in the DePasquale case was, of course, built after July 1, 1997. The town of North Kingstown did not raise this point, so the Supreme Court ruled that it had been waived. As a result, we have continued uncertainty on this important matter, and it involves millions of tax dollars for the town of Barville. The Ocean State Power tax agreement right now is a $2.8 million per year agreement, and as I said, there are only 4 years left. What this bill does is it makes it absolutely clear that all real and personal property associated with any electric generating facilities in Barville are taxable, despite DePasquale. The amendment is very simple. I drafted it at the request of the town. It's not even an entire sentence. It simply adds the words, real and personal property of any facility for the generation of electricity located in the town of Barville are taxable by the town. This should solve the DePasquale problem. I would like to thank again Senator Fogarty for sponsoring this, and I'd like to thank the committee for allowing me to make this presentation, and I can answer any questions about this bill or move on to the other one.
I think you can move on. Thank you.
Thank you, Madam Chair. With regard to S-769, it's important to understand the background and the purpose of this bill. 30 years ago, the General Assembly created the Energy Facilities Siting Board. It gave it sole authority to grant or deny energy siting permits. Since that time, the town has experienced the power plant siting process twice, for Ocean State Power and now for Invenergy. Any municipality that hosts a large power plant like Barville is uniquely affected by the siting process. While the town acknowledges and continues to acknowledge that the authority to grant or deny a license should rest with the EFSB, the town's experience shows that additional municipal input would be beneficial to the siting process in Rhode Island. Therefore, the primary objectives of 769 are to increase municipal and public participation in the process, as well as to ensure that the necessary information is promptly provided to the EFSB during the siting process. It's also very important to point out that this bill would not affect any docket currently pending before the EFSB, including Invenergy's application to build the Clear River Energy Plant and National Grid's companion application to build the transmission lines associated with that plant. It is intended to be prospective only and not to apply to the existing applications. Supreme Court law has made it very clear that if you put your application in on a particular date, you are entitled to utilize the law as it existed on that date. We never put any language in this intending to make it retroactive. If there's any question in anyone's mind about this, we would be happy to agree to any language that makes it absolutely clear, even though I think it already is, that the bill is intended to be prospective only. A few things that 769 does.
Senator Archambault.
Yes.
Mr. McElroy, let me ask you, do you think here that a tax treaty is necessary?
It's certainly necessary from the town's perspective. It was necessary to get the funding necessary to oppose the plant. I testified at public hearings and said exactly that. Please sign the tax treaty. We had a very mixed audience about that. And I think the people who have now seen the benefit, which is active, engaged opposition to the plant, would not have had that ability to fight the plant without it. So yes, from the town's standpoint, yes.
So then, may I, Madam Chair?
Yes.
So then in your practical experience, are you aware of any other power plant that's been built without a tax treaty?
Yes, there are some that have been built without tax treaties, but mostly, to be honest with you, Senator, they are in states that do not allow for tax treaties. In those states that allow for tax treaties, I'm not aware of any plants that were actually built without a tax treaty, although I must say that in this case, the tax treaty was signed very early in the process. And I can't say I'm aware of another one where it was signed quite so early.
And just out of curiosity, when was the tax treaty signed?
It was, I believe it was November or December of 2016. And we've received 3 payments totaling $1,175,000 that have been earmarked exclusively to fight the plant.
Senator Nesselbush.
Thank you, Madam Chair. I must admit I am sort of stuck on this fact that Invenergy has paid over $1 million for you to fight them. And, you know, we've been at this a long time, years now. We all sat up here last year for a very long hearing on this very issue, and we're here today again. And I guess I can't help but ask the question, do you think maybe if you hadn't taken $1 million from them, they might just go away? I mean, is there something that could be worked out?
No.
Because now it seems to me like they're in this for $1 million. They're going to fight you. You know, they don't want you to steal $1 million from them.
No,
and
Senator,
it seems like many people want them to go away.
Senator, this is, as I said earlier, a multi-billion-dollar organization, an international organization. It has built many plants all over the country and the world. And I know for a fact that they have already invested not just the $1.175 million in what they paid us, but over $20 million in the work that they've done just so far in this. So they are in this. They're fully invested in it. They want to roll over us. We're trying not to let them. I will say, I know this question, and so I don't want to get too deep into the weeds about why they would have given us the money. But I will say that Invenergy would have to have paid other funds to the town. For example, a building permit fee would be, it's a $1 billion plant. The building permit fee would be substantial. And part of the negotiations were that the upfront payments that we negotiated that had to be paid regardless of whether the plant ever got built would be in lieu of such fees, such as building permit fees. So my guess is that Invenergy conducted a calculus, and they said, how much would those building permit fees be if we get permission for the full 1,000 megawatt billion-dollar plant versus the upfront fees they're looking for, and we can save money by paying them the money up front, even if they use it to fight us. And they're so confident and frankly cocky about their position that they think there's no way that we'd be anything but a gnat that they're going to slap off their back. The primary objectives, as I said, are to increase public participation and to ensure that the necessary information is given. One of the ways that this bill does that, as has been discussed, is to increase the number on the EFSB from 3 members to 5. That's not a very large increase. In Massachusetts, they have 9. In Connecticut, they have 9. In New Hampshire, they have 9. In New York, they have 7. And in Vermont, they have the 5 that we're asking for. So the 3 is much less than you would expect. Remember the significance and the size of these projects. It takes significant effort to do something like this. Frankly, the 3 people that are on the board already have other jobs. They're the chair of the Public Utilities Commission, the director of DEM, the director of statewide planning. It's very difficult for these 3 people, even if they parse out some of the work, to actually do the necessary work that's needed. We need to know that we're getting a fair shot, that the deciders have the time to be able to fairly look at the evidence. And if you don't increase the board to a more reasonable number, and we think 5 is the minimum that it should be, then I think we're looking down the road at putting more pressure on these members. Again, it would not apply to the Clear River Energy Center project in Burrillville. It would not increase the board for that. The bill would require the host communities to advise the EFSB regarding whether or not the proposal is consistent with all local ordinances, standards, and criteria, including with their comprehensive plan. It will ensure that the EFSB will give serious consideration to any town council resolution supporting or opposing the plan. And it will provide that if a municipality opposes a proposed energy facility and that municipality is already burdened with a facility of 80 megawatts or more, then that new facility cannot be forced on the municipality unless the board is presented with clear and convincing evidence that overrides the town's opposition. The bill also would require the applicant to pay the municipal expenses that are incurred in investigating the proposed facility, in looking at the environmental impacts to the proposed facility, and for training local emergency personnel on issues related to the power plant and their related facilities. Additional public participation includes 3 mandatory public hearings in each host community and stronger public notification requirements. In order to ensure that all the necessary information is given to the board, the bill requires the applicant to provide all required information before a docket will be opened. Right now, in this case, Invenergy was allowed to open a docket without having all of the required information. The way the law is currently written, they can open it up and they can supplement throughout the process. We don't think that's fair. We think we should be given the information, hire our experts, and deal with it rather than being death by 1,000 cuts, which frankly is the way Invenergy's been dealing with it. They bleed the information out slowly so that we can't respond to it. Our bill provides that if the advisory agencies need information that they are not given, Invenergy will be given 60 days to provide that information and supplement their application, and if they don't, then the docket will be closed. I've provided a summary of the proposed amendments together with the testimony that I've presented here today. I also separately submitted an email with one correction of a typographical error. I heard earlier that the sub A is being considered. Maybe that was the correction to the typographical error. In any event, on page 13, line 1, the word appraisals should be approvals, and that's the only error that I found. Thank you again for giving me this opportunity, and again, I'll answer any questions at all.
Thank you. Any questions or comments, Senator?
Thank you, Madam Chair. Again, back on the tax treaty, was that like negotiated by the whole council, or did you do that on their behalf as legal counsel, or I don't know if you have a town manager in Burrillville, or how was that?
We have a town manager. The negotiating team was myself, the town manager, an expert that we hired in energy matters who's negotiated many other tax treaties throughout the country, and 2 members, a subcommittee of the town council. That was the team.
Senator Nesselbush, the piece that's missing from that, the 1.175 million, the piece that's missing from that is the thousands that have been spent by the community. As Senator Fogarty's been a tremendous supporter of the town's efforts, he's been even a bigger supporter, if it's possible, of the community's efforts. And the community is raised through, cake sales, bake sales, chicken dinners, whatever, thousands of dollars that have netted a lot more bang for the buck than you'd think. And I think that part of the strong community objection to this power plant is what allowed the town council to make the decisions they made and move on the way they have. It's, I think, a total town effort. People, government, and representatives here at the legislature working together in one direction, and that is to stop the Invenergy power plant. And if they want to pay $1.175 million, they're more than welcome.